afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion, FTC versus Qualcomm, the recent ruling on antitrust adventurism. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I'm now going to introduce our panelists in the order in which they will be presenting. So first we have John Chu, who's an attorney and expert on political issues, constitutional law, business and financial law, litigation and regulatory affairs, U.S. Supreme Court, and confirmations. He is a regular columnist and media analyst and commentator. Mr. Chu served both President George H.W. Bush and President George W. Bush. He also served Judge Paul Roney, U.S. Court of Appeals for the 11th Circuit and presiding judge of the Foreign Intelligence Surveillance Court of Review, and Judge Stanley Sporkin, U.S. District Court for the District of Columbia, who formerly served as Director of Enforcement at the Securities and Exchange Commission and General Counsel at the Central Intelligence Agency. Mr. Chu served as editor-in-chief of the Journal of the National Association of Administrative Law Judiciary. Mr. Chu is a member of the National Committee on U.S.-China Relations, the Pacific Council on International Policy, and the Foreign Policy Association. Mr. Chu has lectured and published articles on a wide variety of issues such as constitutional law, security and corporate law, regulatory affairs, administrative law, the Foreign Corrupt Practices Act, appellate advocacy, antitrust law, intellectual property, and international affairs. Richard Epstein is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law. Prior to his joining the faculty, he was a visiting law professor at NYU from 2007 through 2009. He has served as the Peter and Kristen Bedford Senior Fellow at the Hoover Institution since 2000. Epstein is also the James Parker Hall Distinguished Service Professor of Law Emeritus and a senior lecturer at the University of Chicago. His initial law school appointment was at the University of Southern California from 1968 to 1972. He served as editor of the Journal of Legal Studies from 1981 to 1991 and the Journal of Law and Economics from 1991 to 2001. From 2001 to 2010, he was director of the John M. Olin Program in Economics at the University of Chicago. Professor Epstein has written numerous articles in a wide range of legal and interdisciplinary subjects. He has taught courses in administrative law, antitrust law, civil procedures, communications, constitutional law, contracts, and a vast array of other areas. First, a few housekeeping notes. So for the Q&A session, if you could please send in your questions through the Q&A function that you'll see at the bottom of the taskbar on the Zoom platform and type those into me. You can send those to me anytime and I'll get to them. It's easier than kind of interrupting the panelists at the end to ask questions verbally. That would make things a lot easier for me. A quick plug for something Committee for Justice is doing first. We have a coalition of organizations working on issues related to antitrust law and particularly focusing on the misuses of antitrust law and the original purpose of that law. That's called the Alliance on Antitrust, which you can find at allianceonantitrust.org. So I wanted to give a quick plug for that. And with that, John, the floor is yours.
Thank you, Ashley. Thank you, Richard. And thanks to all for joining us on this webinar. The Ninth Circuit recently held that Judge Lucy Koh in the district court was wrong when she held that Qualcomm was liable for antitrust violations with its chip and licensing policies. For those who are not familiar with the case and for who are not familiar with some of the terminology, you'll hear several acronyms that we should probably address first. So the common ones are SEP, which stands for Standard Essential Patents. Another one is FRAND, F-R-A-N-D, and that stands for Fair, Reasonable, and Non-Discriminatory, ND, Non-Discriminatory. And that's a standard that the tech industry has for pricing. So you generally hear that with fair, reasonable, and non-discriminatory pricing. And those are, and another one is OEM, Original Equipment Manufacturer. And those are the ones that you'll hear very commonly. So this case has been going on for quite some time. In 2017, January, the FTC sued Qualcomm in the Northern District of California. Qualcomm is based in the San Diego area. The main crux of the FTC's allegations were that, number one, Qualcomm had a no license, no chips policy. In other words, if a rival chip supplier, Motorola, Intel, whomever, if you didn't buy the license for Qualcomm's patent portfolio, you couldn't get any chips. And that was true for the OEMs as well. Another issue was having to do with money. Judge Koh was not happy with the fact that Qualcomm made a lot of money. Qualcomm makes about 2/3 of its profits through patent licensing, not product sales. And both the FTC and then later on Judge Koh really had a problem with the fact that Qualcomm has and had a unique business model and that they were doing very, very well. Last and certainly not least though, both the FTC and Judge Koh had a problem with the fact that Qualcomm had an exclusive licensing agreement with Apple. Apple, of course, makes the famous iPhone, and Qualcomm and Apple had come to a licensing agreement. It was exclusive, and both the FTC alleged and Judge Koh agreed that the data rate arrangement was anti-competitive. There's some inside baseball stuff surrounding the actual filing of the lawsuit. At the time, that 2017, it was during the Obama administration in January. After the change on January 20th, again, you had a situation where and the lawsuit was filed over a dissent from one of the commissioners, Maureen Olhausen, which is very unusual for those who are familiar with FTC practice. Later on, with Chairman Simons, Chairman Simons was forced to recuse himself. There is some debate over whether that recusal was actually necessary, but with the recusal, any vote was left to 2-2 amongst the remaining commissioners, and so the lawsuit continued to proceed. After the trial, the Department of Justice, via the Antitrust Division, they filed papers describing their stand, which was inapposite to the FTC stand on the anti-competitiveness, and they also filed papers with respect to a national security issue. Qualcomm had been involved with a CFIUS, or a Committee on Foreign Investments issue, and the idea was that Qualcomm was the country's leader by far in 5G and in Internet of Things technologies, that kind of thing. And so post-trial, the DOJ filed a brief with respect to national security issues that might happen if Judge Koh's ruling, which came down in February 2019, she had basically slapped Qualcomm with a very, very, very hard and broad injunction, where she essentially required Qualcomm to renegotiate every single one of its license and other contractual relationships. And that would have been very bad for Qualcomm and bad for its business model. So they appealed to the Ninth Circuit. And that's the case that we're discussing now, because the Ninth Circuit came down with its ruling, completely reversing Judge Koh on her rulings and vacating the injunctions that were placed on it. A few points that I thought were very interesting. So the 3 points. So for number one, no license, no chips. In antitrust lingo, we call it a duty to deal. There is an issue of whether, if you're a business, and more importantly, a patent holder or any other kind of property rights holder, are you required to deal with other entities, especially your competitors? The Supreme Court, in a case called Aspen Skiing from the early 80s, Aspen Skiing involved 2 companies that had ownership of, 4 companies that had different ownership of the various ski hills and mountains in Aspen. And there was an issue over whether one of them, by declining to participate in joint ticket sales, was involved in anti-competitive conduct. That's a case where really rich people problems come to the Supreme Court. Another one is the Trinco case. And that's the one where you hear the quote very often, that, quote, this is Justice Scalia's opinion from 2004, Aspen skiing is at or near the outer boundaries of Section 2 liability with respect to a duty to deal. So the FTC had alleged that because Qualcomm had a no license, no chips policy, and because Qualcomm's patent portfolio was and is huge, that automatically led to anti-competitive behavior and should have been considered anti-competitive conduct because that harmed the consumers. In this case, both rival chip manufacturers and other downstream cell phone manufacturers. The trial went through a lot of testimony from the various manufacturers. I have a list here of all the OEMs that were allegedly harmed by Qualcomm's conduct. We have LG Electronics, Sony, Samsung, Huawei, which is the infamous, perhaps, Chinese company that's been in the news recently, Motorola, Lenovo, BlackBerry, Curatel, BenQ, capital Q, Apple, which we've discussed a few minutes ago, Vivo, all caps, Wistron, Wistron, Pegatron, ZTE, all caps, that's a Chinese company that the president actually saved, working with President Xi in China, Nokia, and then several other smaller Chinese OEMs. So if to quote Judge Kuo, Qualcomm engaged in anti-competitive conduct. To quote the Ninth Circuit, Qualcomm's licensing practices are not anti-competitive because Qualcomm is under no antitrust duty to license rival chip suppliers. And the idea is that with FRAND, the fair, reasonable, non-discriminatory pricing, that's basically a contractual way to limit prices. Some people call it rent control for IP. But it is a contractual issue. And I think the Ninth Circuit felt, and I think the Supreme Court would uphold, that if Qualcomm was in fact breaching its obligations to license patents on a FRAND basis, then that's an issue that belongs with a contract violation suit. Maybe a patent suit, but probably a contract suit, and definitely not an antitrust suit. Now I understand if a private entity wanted to sue under antitrust, because you can get treble damages, et cetera, et cetera, et cetera. But from my perspective, it was a little unusual for the FTC to do it, absent a political desire to go after Qualcomm and absent a political desire to expand what Section 2 liability and a duty to deal is. The FTC and Judge Koh had also alleged and held that the no license, no chip policy also imposed basically a surcharge or a tax on rival modem makers like Motorola or Intel chip sales, and that any royalties that Qualcomm was charging would be considered unreasonable and therefore automatically anti-competitive. I personally was very skeptical of this from the beginning on a basic, very, very, very basic level, because it seemed to me that the FTC was asking Judge Koh to analyze the whole situation from what antitrust people call a per se standard. And I was not convinced of that from the beginning. Judge Koh obviously thought that I was wrong. And the Ninth Circuit, I think, although it did not discuss per se or the other alternative rule of reason, I think the Ninth Circuit probably would agree. If it was analyzed under a per se standard, probably not the right way to go. The other thing about the technology surcharge for the no license, no chips policy, first, it wasn't clear that the surcharge was actually excessive. And although the FTC had brought forth several witnesses, some fact witnesses, some expert witnesses. It didn't seem to me that they actually were able to testify and show that the surcharge was excessive. And then second, and perhaps more importantly, it didn't seem to me that the surcharge would prevent any OEM from obtaining chips from either Motorola, Intel, or some other company. As a matter of fact, at some point during the Qualcomm FTC saga, Apple had announced that they were going to buy chips from Intel. And then, of course, Intel later on decided that they were going to exit completely. So, again, to me, that was kind of telling that there should have been at least some question that the antitrust liability perhaps was not where the FTC thought it should be. And another issue is pricing. The classic antitrust pricing situation with a solo actor is where a company or an entity uses its monopoly power to charge very, very low prices to keep rivals out. But here, it almost seemed like the FTC was saying that Qualcomm charges high prices. And therefore, if they wanted to, other chip makers could come in and charge lower prices. But that doesn't seem to me to be anti-competitive behavior. That seems to me to be quite the opposite. And plus, because Qualcomm's licensing scheme, no license, no chips, was applied equally to everybody, again, it seemed to me that Qualcomm was not necessarily targeting any rival chip manufacturer in particular. I think some wags would probably joke that the FTC just wasn't happy that Qualcomm was making a lot of money off of its no license, no chips plan. And the problem with that theory is that, or the problem with that FTC theory, if it is true, is that making a lot of money all by itself is not illegal. Now, I will say, if the opposite were true, if Qualcomm said no chip, no license, yes. I'm not sure that would have been all right. I think if they had that scheme, I think they would have been in a lot of hot water because a company who did that, it kind of looks like Qualcomm would have been using its market power to force other companies to buy its chips if you wanted to license the IP portfolio. But that's completely opposite of what was happening here. It was a no license, no chips. And so I just think that the FTC misunderstood that. And I think Judge Koh understood that. Unfortunately, the Ninth Circuit was able to reason through all of the changes. By the way, the Ninth Circuit vote was 3-0. And one of the judges was a visiting judge from Michigan, I think, Judge Marshall III. So it was a 3-0 vote. There is some talk. I saw on the news that people are questioning whether the FTC can apply for certiorari to take this to the Supreme Court and get justice for the poor little OEMs and rival chip manufacturers. I don't know if that's the case because, number one, the commission would have to vote to get to certiorari. If they only vote 2-2, then that's not going to get there. And second, I don't think that the FTC has independent litigation authority. I don't think that the Solicitor General's office would go along with this. So I'm not sure that they can apply for cert, let alone whether it's a good idea. So this being the one case where the Ninth Circuit may have gotten it right, I'm going to turn over to my friend and colleague, Ashley Baker, who will then introduce Professor Epstein. And Ashley, you're on mute.
Thank you, John. I know Professor Epstein, last time you were on our webinar, I asked about the Qualcomm case, and you said you were too angry about it to speak, and turned it over to the other panelists. I know you've never really been speechless. Is that still the case here?
No, I wasn't even speechless then. It was just a bit of amiable hyperbole designed to let people know the intensity of my objection to the case. I will say at the outset that just to make it perfectly clear, I've had a sort of ongoing professional relationship, not that I've worked on the particular case with Qualcomm for many years now. And this is born of the fact that there's a sort of basic similarity of view between their positions and my positions as to what's going on. And so what I wanted to do is to sort of put this into a slightly more theoretical framework after what John has said, in order to see the way in which this goes. There is, at this particular point, a very powerful debate which is taking place inside the antitrust law, which could be characterized in the following ways. The traditional University of Chicago view, embraced by many others, most notably associated with the names of Robert Bork and Richard Posner, took the position that there was a single objective of the antitrust law, which was to propose various forms of efficiencies when you start to deal with complicated product markets. And the first rule that you would have is where it is possible to have a competitive market, because people can function independently of each other. Competition is the appropriate sort of arrangement. And hence, if there is some kind of cooperation amongst the various parties, generally speaking, you're going to apply a per se rule. The label is somewhat of a misnomer, but what it means is there's a very, very strong presumption that has to be rebutted by very specific evidence, which says when two people get together in order to form a firm in this particular way, what you're going to see through these cartel arrangements is no efficiencies in production, because they'll do it exactly as they did before, but there'll be a reduction in output and an increase in price. The naive may think that this is simply a transfer of wealth from one group of shareholders to another group of shareholders, but the antitrust law will note that there's some kind of a deadweight loss associated with this particular transfer, because as the price starts to go up, certain transactions that would have taken place at the competitive level will no longer take place, and the loss of those transactions creates not a transfer of wealth, but the deadweight loss, which makes this inappropriate. The reason I say that this is a general presumption is in many kinds of markets, for example, in banking and so forth, the only way is in which parties can compete in consumer markets is to cooperate in the production of various sorts of goods. So it's not possible to run a checking business, for example, unless a bank that gets a check from one customer can basically cash it in a different bank. And so what happens is the banks have to develop all sorts of clearing mechanisms so that the money can go back and forth between them. I've actually been involved in working some of these arrangements. And what typically happens is everybody sits down and says, how can we make the transactions the most efficient they could possibly be? And then it's understood, we're here to do this on the technical side. We're not going to talk about prices. We're not going to talk about rates or anything else that could bring the antitrust laws to bear upon them. Companies are extraordinarily sensitive about these kinds of issues. And John mentioned the so-called FRAND obligations, and it's important to know exactly how those things often take place, because the technical committees dealing with FRAND interconnections always operate independently of the pricing committees that are associated. And the hope is to try to figure out how it is that you get the best set of interconnections that are available, taking into the mix various kinds of companies whose technical work seems to fit in with the technical work of everybody else. And there is no way in this kind of an industry, a network industry, that you can have freestanding competitive companies, which is why it is that network industries and based upon standard essential patents have themselves a very different kind of feel associated with rate of return regulation. People who are familiar with the industry will know that this is no different in principle from the situation that you have when you have networks associated with telephone companies or with railroads. These were issues that arose essentially at the beginning of the technological revolution over 100 years ago, and the solutions are remarkably similar today to what they were in those times. What's interesting about this particular case is that these are not standard essential patent type issues. These are essentially straight kind of competitive sorts of issues that you have to face. And so essentially, you don't have to worry about justifications for cooperation amongst parties. By the same token, if one looks at this, it's very significant to understand that there's only a single defendant in this case, which is Qualcomm, which means that there was no effort whatsoever to show that it was engaged in league with some other people to engage in this stuff. And there is a kind of a central theorem of economics, which is that unilateral practices by a single company, generally speaking, are going to be subject to far less scrutiny than cooperative activities that take place across companies, because the cartelization isn't there. John mentioned something which is actually really very, very interesting and very difficult. He's quite right to say that the no license, no chip policy makes perfectly good sense. As the Court of Appeals talked about it in this particular case, if you ran a rule of reason analysis on that, there are enormous efficiency justifications for having that particular kind of rule. Two of them could be mentioned right now. First of all, even smaller companies that don't have any kind of dominant position tend to use identical type arrangements with respect to their technology and with respect to their chips and so forth. And essentially what happens is, if you can see a non-dominant firm engaging in certain kinds of practices, it shows that at the very least it has some kind of efficiency justification, at which point the burden ought to shift upon the government to show that there's a hidden collusive moment that could take place under these areas. And what John said quite rightly is that if you actually have to sell the chips without showing the license, your life becomes a nightmare. It turns out if you have to sell them to your rivals and then they sell them down to an OEM, you do not have any rights given the patent exhaustion rules in a case called Quanta against LG. Life is good. And so what you want to do is only sell it to the OEM companies. And then you even have troubles because if they have further sales, the patent exhaustion rule, a silly rule to begin with, makes it much more difficult to do this. The idea that somehow or other you have to sell it to your rivals and then have no control over what's going to be done with your equipment after they sell it is in fact a very, very serious problem. And the court in this particular case, basically Callahan hit on this point multiple times. What was so striking about Judge Koh's opinion, one of the reasons why it was such an inept piece of work, is that any potential efficiency justification that might have been considered with respect to unilateral practices was systematically pushed to the side. And what happened is you got nothing whatsoever to deal with that issue. It was also the case, for example, in something like the Linksys case, what happened is you looked at the case, and what Chief Justice Roberts did is said, you know, if you want to raise your price in one particular market and it makes life difficult for other people, that's exactly the way in which competitive markets ought to work. And if you do it too much, you will lose your customers. And in fact, if you raise them and you keep your customers, it also has a positive competitive impact. Higher rates of return induce more rapid technological innovation. So it's not at all clear which way the innovation front goes by trying to dictate from external sources whether or not the price is too high or too low. That was something that John hinted at when he started the talk, is that you need a very powerful metric to figure out what is an unfair price, and the antitrust law simply does not supply us with any of these kinds of things. And what was so distressing about the way the case was argued is the government managed to say that the case was in its favor when it was in fact a judgment with a summary judgment for the defendant in this particular case. And so you get this topsy-turvy universe in which cases in which the government has lost is now, and decisively, are treated as though they're somehow or other authoritative in the way in which this stuff ought to be done. And that, of course, is, again, it's just a sign of bad faith. I mean, it's a really very, very bad case. John mentioned that this case was brought on January 17th, 2020, 3 days to go in the Obama administration. It should have never been brought. Generally speaking, if you're talking about something with long-term implications, the last thing you want to do is to do it on the last day of a president's term. This is what happened in the Johnson administration in 1969 with the dreadful IBM case, which drug on for 13 years before it was dismissed. And the same thing is done in this particular case. As a matter of decency and comedy in these circumstances, if you know that you're going to be out of office when the case is going to be litigated, you don't bring it, you trust it to the next administration to decide one way or another. And here it was even more ironic because the Justice Department from day one was firmly opposed to it. Commissioner Olhausen, as John mentioned, wrote a very powerful dissent saying, you haven't shown anything about the unreasonableness of prices or practices and so forth in this case. Why are you bothering us with this? Now, if you start looking at some of the doctrinal points, I'm just going to mention a couple of them. John referred to the Aspen case, and I just want to talk about it a bit more. It was a case in which there were 4 companies that had entered into an arrangement in which if you bought a ticket, you could go to any one of these 4 lift companies on the Hill. And the theory was that there's a real efficiency gain on that because you lower the transactions cost and the companies still have to compete for the dollar by the way in which their various equipment starts to work. But what happened in this particular case is the allegation was made by 3 of the companies that the 4th company did not keep its Hills up to the same level. So if it's going to get 1/4 of the revenues out of this situation, but it's not going to perform to the same situation or the same levels of anybody else, it's going to be a cross-subsidy situation. And so what they did is they terminated that. The first observation is if you want to break up a 4-part arrangement into a 3-part and 1-part, it certainly doesn't look like cartelization and so forth. They have to think of some kind of exclusive practice. And then if you look at it, there's a pretty obvious efficiency justification associated with that case, which was not fully understood by the court. So when Justice Scalia got in the Trinco case about 15, 20 years later, the same question. He said, this is at the outer limits of these situations because you ignore the efficiencies that are associated with this practice and have this very weird theory of exclusion. And generally speaking, I think since the Standard Oil case in the 1940s and so forth, the overwhelming consensus in the antitrust situation is there are very few per se offenses involving unilateral conduct. John made that particular point. One wants to be extremely emphatic in these circumstances to say that you don't want to do it. And then there was the situation with respect to Trinco and so forth, which was also an extremely complicated type situation involving telephone companies. And the question as to whether or not you're under a duty to give internet connections to your rivals when you start to run your kind of business. And what the basic rule in that case is that nobody is under a duty to cooperate with their competitors so that they'll be in a stronger position. The theory is sure that the competitor may be very happy to have the subsidy, but the original company is certainly very loath to pay the subsidy, and you will not induce people to enter a market if they know that somebody else can come along and poach all of their hard-earned labor and set themselves up in direct competition. And it's even worse than that because the new guy gets to come in without having to bear the cost of innovation, which was done by the first mover in these markets. And what Judge Koh did is she said, well, there's an exception to this when there's a prior dealing that has taken place. And then she made one of the most pathetic arguments I've seen in a very long time, saying, well, Qualcomm had to deal with some of these companies in 1999, unrelated transactions, different universe and so forth. And to sort of treat that as the predicate for saying you would agree to this particular kind of an arrangement was frankly laughable. It was preposterous, and that's exactly the way in which the Ninth Circuit started to treat this sort of issue. This was not just a wrong opinion that she wrote, it was an opinion that was so wrong that it was just completely off the reservation in terms of the ways in which it started to deal with these things. Now, I'll just mention a couple more minutes and I'll stop at this. There's some other features about the case which I think are really quite extraordinary. The first of these things is, this is a case brought in the Northern District of California. And it turns out what she did is enter a worldwide decree announcing that Qualcomm was under a duty to renegotiate contracts with all of its customers worldwide based upon her perception of what the American antitrust law applied. I think John would agree with me, extraterritorial jurisdiction is one of the diciest and touchiest systems in dealing with antitrust law. The rule that in fact is quite controversial, but at least understandable, is if somebody forms a cartel in Western Europe and then sells at elevated prices in the United States, America, even though it doesn't control the cartel companies at the point of origin, has an effect in this area which may justify trying the antitrust laws against other guys, at least if you have the reciprocal rule against American companies. That's a very, very hard question. But in this case, what she was doing is she was regulating the conduct that Qualcomm had in Korea or in Japan or in China, and when there's no spillover effects into the United States as well. And the obvious answer in that case, they've got their own antitrust authorities. Qualcomm will have to deal with them in one course or another, but it would just be a real intrusion, a State Department issue for the United States to come in and say, we're going to demand all of these contracts being renegotiated. And it would be a calamity of justice if the Korean authorities say, oh, the American court is organizing this, the question has now been litigated, we're just going to require them to cut the rates by 50%. You cannot run a particular legal system with that particular view with respect to extraterritoriality. And so what happens is the second problem is that we know that there are two general mechanisms, and I'll end on this. One of them is the antitrust law, where basically the kinds of remedies that you want under antitrust law are a structural or conduct-based in the following way. Structural, we're going to divide you into two companies because we think it's more efficient. That would be madness to do in this case. Or practices, you can't use the no license, no ship policy, you have to use something else. But what she was prepared to do is to turn her court into a rate regulation body in which virtually every contract would have to go through rate of return regulation. We don't know what the base is. The technology is highly changeable. The cost structure is very, very flat. Prices are going down rapidly everywhere. New entry is coming into this case. John mentioned that Qualcomm essentially lost its entire book of business to Intel. It brought a suit against Intel for stealing trade secrets through Apple, which was very bitterous between the two of them. It turns out that the Intel chips didn't work, and so they came right back and paid a very substantial penalty to Qualcomm to reintroduce the other situation. And so the point you want to make about this, all or nothing contracts may seem very, very bad, but uneasy lies the head that wears the throne. You have an all or nothing contract today. You may have a nothing contract tomorrow, because if the technological innovation comes, it's going to be quite possible that you'll lose everything instead of having a gradual deterioration. There's no automatic rule one way or another what's going to happen. Qualcomm has lost market share. Prices have gone down. This is a market working the way in which it should work, and we should all thank the Ninth Circuit for setting things right. And I agree with John. It's likely that the impasse in the FCC and the FTC means that this case is not going to be relitigated.
Thank you, Richard. So to pick up where Richard left off regarding contract law for the discussions, I mean, it seems Judge Koh essentially ruled that breaching this contractual obligation, whether or not that breach occurred, was an antitrust violation, which permits more intrusive remedies. Why are we seeing this trend of conflating contract law with antitrust law? And is that something that, you think we'll see more going forward after this case?
Treble damages is the obvious motivation. We will see less of it going forward, because the basic argument is you're under no duty to enter into a FRAND obligation. You're entering no duty to essentially license your standard essential patents to any larger group. So if you're not in a violation of the antitrust law, if you don't participate, why are you in the violation of the antitrust law if you've decided to participate and then claim you're entitled to withdraw? It may be you are. I think we've lost John for a second. It may be that you're not under these circumstances, but that's a question of what the terms of the original contracts are. And by the way, just to sort of push this thing a little bit further, these SEP agreements are amazingly sophisticated. And if you start looking at them, they figured out, as I've mentioned earlier, how you put these things together when you separate the technical stuff from the other stuff that starts to happen, mainly the pricing things. If you start looking at the arrangements, it turns out as the agreements become larger and more complicated, the price structure seems to be going down all the way. And so it would become a mistake, I think, to argue, as Mark Lemley and Carl Shapiro has, that what you see is here is a huge set of holdout problems. If you have holdout problems, you get no contracts of one kind or another. And what you see here are contracts with declining prices, which is what you would want to see. Anyhow, John, did you hear the question? She wanted our views on the relationship of the contract remedy to the antitrust remedy.
Oh, well, I mean, my feeling is that if in fact any entity was upset about Qualcomm's no license, no chips policy, they would have been much better off suing as a private entity for contractual violations of FRAND. Again, I think I touched on it earlier. It doesn't make any sense for the FTC to go after an antitrust violation. It's not like the FTC can benefit from treble damages. So, and I think Richard's points are right on the money. And the fact that, as Richard pointed out, cell phone prices keep dropping and the technology keeps improving. And that's what the market's supposed to do.
Yeah, I mean,
sorry, go ahead.
One of the things to understand is there's two kinds of markets in which you deal with regulation, and they're completely different. One of them is the standard public utility model, where you have a huge bit of fixed infrastructure, which you have to amortize over 10 and 20 years, and where the improvements in technology tend to be incremental because you're basically required to have a huge power generation system and all of these offshoots. And in those circumstances, the great problem that you have is that if you allow the rate regulation to be too aggressive, companies that have fixed costs won't be able to recover their fixed costs, but they won't be able to leave the business because they're getting more than their marginal costs with respect to the rest of it. So starting in the 1890s and working all the way through 1940 and so forth, the general rule became is that you're entitled to get a reasonable rate of return on your invested capital, not just a return for the marginal cost subject to observation. But since your customer base turns out to be relatively stable and your technology base turns out to be relatively stable, you could start to make these relatively long-term projections with relatively modest stuff. In the technology business, if you got whatever it is, Murphy's Law, whatever it is taking place, and everything is dropping by 10% a year, 20% a year, and so forth, rate of return regulation on that kind of capital base makes no sense. And in fact, if you're trying to figure out what rate system you do, you have to ask yourself, if they're dropping naturally so much, what are you going to try to do? You could try to say rate caps. Every year you get 10% less than you did the year before. But if you misguess on that one in 1 year, it can be chaos. So there's a famous set of papers starting in 1968 by Harold Dempsey called Why Regulate Utilities. He even thought that rate regulation in a dynamic utility of the traditional variety was dicey. Once you do it to this modern technology where you don't know what the rate base includes, it doesn't include, and all the rest of it, rate regulation turns out to be a dead loser. And that's what it was that Lucy Coe had demanded take place in the Qualcomm case.
So also, like, what, if any, effect do you think the Qualcomm decision will have on how markets are defined in future antitrust cases? Like, what is important of the Ninth Circuit holding that the relevant effects must be combined to the actual product market and not to ancillary markets?
Well,
go ahead, Richard.
Look, I mean, in all of these type of situations, the definition of what counts as a relevant market is absolutely critical to the way in which you start to do things. And what you're generally trying to do is to find a system in which the rate of substitution between the products that you have and somebody else's products, or one kind of product and another kind of product, is close enough that the shift in prices in one will alter the shift in quantity of the other. And there's something called the CDMA chip or so forth. And they defined this market relatively narrowly. If you defined it so narrowly so that the only thing that fit within the market was the peculiar variation on that chip, which was monitored by Qualcomm, then by definition, you have a perfect monopoly, because everybody is the only person who sells his or her own property. And this would like be saying, if you happen to live at 40 Swarthmore Avenue in Pennsylvania, you have a monopoly over that property, even though when you go to the multiple listing services, there may be 20 other comparable properties that you're going to have to deal with when it comes to sale. So you don't want to make it too narrow, and you don't want to make it too broad. And if you go back and you read the sort of the antitrust guidelines that were put together first in the Clinton administration, then in Bush 1 or Bush 2 rather, and so forth, they are basically pretty sensitive to these kinds of issues, trying to find this. And so one of the things, for example, that John and I didn't mention is, what is the product? Because what happens, they don't charge for the chip, they charge for the chip as part of the final product, i.e. the handset or whatever it is. And somebody could raise the argument, the final product is not the handset, it's not the assembly on the dashboard of an airplane, it's the entire telephone network, or it's the entire 747 aircraft that you're flying. But nobody's ever priced it that way. And it turns out small companies as well as big companies tend to price off of this end arrangement, because if you don't do it in that particular fashion, the technological and administrative techniques become absolutely nightmarish. And so it was the point that I had mentioned before. If everybody's doing it in the same way, then you have to assume that either everybody's crazy or everybody knows what's going on. And it's no way in the world that a single appellate judge or a trial judge is going to have more concentrated expertise on how these markets work than the people who have to deal with them every day.
And I would add that with respect to the definition of markets, first, by definition, intellectual property or any other kind of property, Richard mentioned, a house on Swarthmore Avenue, that you have the power to exclude. That's the whole point of it. And Qualcomm has a big portfolio of patents. And number two, the Ninth Circuit opinion says specifically, the panel framed the issues to focus on the impact, if any, of Qualcomm's practices in the area of effective competition, the markets for CDMA and premium LTE modern chips. And the irony is that, everyone's moving away from CDMA as it is. And even LTE, we're trying to move towards 5G and beyond as quickly as we can, hopefully ahead of the Chinese or anybody else. So even this case is already behind, in a way, behind the times and behind the technological development.
Yeah, I mean, you cannot, when product cycles are 18 months, you can't have a 20-year plan for figuring how you do it. You build an electrical generation plant, and you get 20 years, and then you have to make some stuff. And that system of rate regulation is well understood, but it is completely inapplicable, and all the market participants understand that. So the basic argument is, do you think you're better off dealing with holdouts by having mandates from government, or better having a series of institutional practices where everybody knows that if they don't get this thing done today, the revenue losses will be enormous? And so then you look and see what's the level of breakdown. This is not labor negotiation, management against labor, where you get strikes all the time. These guys are going to kill each other, all of them, if these things tend to fail. And so what they do is they have a very high rate of compliance. And if you start doing industry surveys and ask people whether or not they think the government can actually improve the functioning of the pools that they have, there's nobody in favor of the intervention except a few academics, for the most part, who have not actually worked day to day in this business.
So let's take a step back to like kind of the 3,000-foot view of this right now in the context of the broader debate that's going on over, how to apply our antitrust laws in Congress. You have Tim Wu and you have Carl Shapiro making these arguments that we need to revise essentially our antitrust laws to deal with these new technologies, or deal with how like antitrust applies specifically in the IP context. How do you see this influencing this broader debate, and what do you see as being kind of their next arguments?
Well, my view about this, I've actually written something very critical about Tim Wu and his stuff about the curse of bigness and so forth. And I think the simplest form of the objection is it wasn't even clear that Louis Brandeis got it right when he was starting to talk about these issues back in about 1910 to 1920. To give one illustration, there was this campaign to break up Standard Oil, and it actually succeeded, but there's a lot of contemporary evidence which said the entry of other companies with different technology was already doing its work. It's not thought that that particular decree actually created a large degree of harm, but other kinds of consent decrees in which they take vertical integrations like the movie pictures and break them up, not at all clear that you get any efficiencies associated with their operation. And ironically, the single best opinion in antitrust that Louis Brandeis wrote had to do with the question of trading that took place in the Chicago Board of Trade before ours, in which somebody had found that this was a per se illegal offense because you had a very limited number of buyers and sellers at the beginning, right? So it was kind of a cartel situation. And he said, when he looked at it, is you have this monopoly so-called for 2 hours, and then an open exchange goes, you can't exploit anything. So he actually took this case from per se illegal to per se legal under a rule of reason. So Brandeis was a very complicated kind of character, and I have seen nothing whatsoever which makes me believe that you want to go down this road. The area in which Wu has the greatest traction, and I think he's probably wrong there, is when you start having large companies like Facebook take over other kinds of companies like Instagram. I don't know the names of all these companies and the like. And then it turns out these companies become behemoths. But the implicit assumption is if they hadn't been taken over, they hadn't gotten that infusion of capital and intellectual property, they would have done every bit as well on their own. And it may well have been that they would have failed on their own because they didn't have the expertise of Apple and the technology of Apple behind them. So it's extremely difficult when you're evaluating these things to say, aha, here you've got a taken over country, which is a really powerful rival. If it had not been taken over, it may not have had that particular structure. And so what you then have to do is to figure out whether or not the FTC, when it examined these kinds of arrangements, simply misunderstood the competitive impact. And generally speaking, in an industry which has high levels of small startups and entry and so forth, a big company takes up one company, that's not anti-competitive for two reasons. One is other guys may become independent. And two, other guys may say, look, you can make a fortune selling out to Apple. It may well increase the number of entries into the beginning space, precisely because they know there's a ready market of large players who will buy them out and make them even richer. So all of these parts are moving the same way, and it cannot be assumed that the rate of entry and the rate of success of companies without the acquisitions by major companies is going to be the same, or let alone better than it is. And so generally speaking, a little bit of humility on this market probably goes a long way.
Absolutely.
And Richard's example of Standard Oil is the classic, and I would expand on it by saying the government was successful in breaking up AT&T, but today, there are people who don't even have a landline, who only use cell phones. Mm-hmm. And then with respect to the Microsoft case, and full disclosure, for a part of the trial, I was seconded to Judge Jackson's chambers back then. And the Windows case was basically a tying case involving Internet Explorer, Windows 95, and Netscape Navigator. Well, nobody uses them anymore. And even by then, people were already moving away from Windows 95. And so, I mean, if you were to ask a 10-year-old today, hey, how about that Netscape? I think the 10-year-old would be like, you're crazy. I don't even know what that is.
Yes,
So,
I know what it is.
Yeah, that's because you're not 10 years old, Richard.
No, but let me mention one thing. There was a very powerful report that was put in by Kevin Murphy from the University of Chicago as to why it was that Netscape failed and Microsoft succeeded. And it was a very good technical explanation. It turned out that Netscape built an integrated subject. So the only way you can go from Netscape 1.0 to 2.0 was to start over with every unit simultaneously. And that's an extremely laborious process, and essentially you're going to miss the market. The way in which people do this much more efficiently was the way in which Microsoft did it, which is they made modules. And the way in which you define a module is that you think if you have 6 or 7 different stages in a process, and inside the module, you can do whatever you want, so long as the inputs lead the same outputs from that particular module. So when you want to redesign the thing, you could redesign the weakest module first, so long as you are compatible with the input and with the output, and then substitute it in. Then when you have the new chain together, you now look at your next weakest module, and you can upgrade that one. So by having the separability, you can essentially make much more rapid and much more accurate changes, because you don't have to go from 1 to 2. You could go to 1 to 1.1 to 1.15, and so forth. And that was the key major feature. That's a straight efficiency kind of argument. And there was nothing whatsoever about the market power of Microsoft, which made it impossible for Netscape to use modules. Now, I think I have this right, don't I, John? You know this much better than I.
Yes, yes. Oh, it's almost, Richard, as if you were part Asian.
I don't know what that is. I'm just all Jewish.
I would also add that actually you were, talking about the Congress amending the antitrust laws. Certainly Congress has the power to do that. I would encourage Congress, if they ever came around to it. Antitrust is not exactly the sexiest issue on the Hill, especially during an election year. But I think the core concept that bigness or a big company in and of itself is not automatically anti-competitive. Mm-hmm. You can be big and still fall well within the antitrust parameters. So my hope is that if Congress decides to pursue this, that they keep those core principles in mind. Because if they do decide to change that, that would be very dangerous, because that would change the entire U.S. economy, which would affect the world economy.
My hope is that particularly Republicans will drop this newfound presupposition that big is bad, because it's very much at odds with all of the arguments that have been made for the past 50 years. But we have time for one our audience question, and it is, I'm not sure if this is one that you can answer, but maybe speculate on. What is the likelihood that FTC Chairman Simon, now free from recusal, will give the agency thumbs up to appeal? And what is the prospect of the DOJ Antitrust Division continuing in a right understanding on these matters under a new administration?
Well, the one thing that I still have trouble understanding is what happened all of a sudden that Chairman Simons decided it's okay to unrecuse. I mean, the situation is essentially the same, except we have a Ninth Circuit decision now. Whatever. Oh yeah, this was after the decision came out. He decided to unrecuse himself. So I mean, whatever work he did while he was at the firm, it's still there. It hasn't changed any. But at any rate, with his unrecusal, I think the chances are even worse that the commission would vote to grant or to pursue certiorari. And that's assuming, even if he did not recuse, even if it was a 4-commissioner vote, it still would be 2-2. And a 2-2 tie vote is the same as a no vote. So, and then even if by some strange thing, the commission did vote to pursue a petition for certiorari, the FTC does not have independent Supreme Court litigation power. They would have to go through the SG's office. Well, right now, we don't even have an SG. We have an acting SG in Jeffrey Wall, who was very talented and
My student, as it was known.
And a great litigator, and he had a great professor. But generally, acting SGs, they don't like to take cases that are super risky or super controversial to go to certiorari, especially when they think they're right. The DOJ had taken the position in the first place that the Qualcomm prosecution by the FTC was not right, that Judge Koh's decision was bad, and that Judge Koh's decision failed to consider the national security implications, which are very important to both the Antitrust Division and the National Security Division. Right. So I think this is one of the unusual cases where I have a hard time seeing the Trump administration, going for certiorari to flip the Ninth Circuit. It's one of those rare cases where the Trump administration actually appreciates the Ninth Circuit. Now, having said that, there is one thing, and that's an en banc review. I don't see the possibility of that. I think, Richard, I think you were just about to interject.
Yeah, I was about to. First of all, I didn't know that Noel had resigned. He was also one of my students. He and Jeff were two of the best students I've ever had, right? And so
Noel went back to the firm.
Oh, he did?
Yeah, he did.
I just good. Okay, that's fine. I mean, and I'm not going to do. My view about it is I think this thing has a sufficiently tangled history, and you also have to look at the strength of the opinion. This is a very good opinion. Generally speaking, I think most of the people on the outside, regardless of which way they came out on large antitrust issues, were relatively sympathetic to Qualcomm. One of the things to understand about Qualcomm is it's not a consumer-facing company. It tends to deal with the trade. And so you're not going to get any political points by beating up on a company that the Defense Department and everybody else wants to have. John mentioned, you're going after companies because they're big is bad. One of the things that makes this true is all these companies have very different markets that operate in very different ways. Amazon is not a network industry, it's a delivery service, and it operates in 1,000 different sub-markets. The prediction of the antitrust gloom and doom types is, well, they're big, that means anytime they enter the market, everybody else is going to roll over and die. But it doesn't work that way. They have to be able to get some customers. Small companies have very good personal relationships with these various operators. There's going to be a situation where there's going to be geographical diversity, and a company which specializes in the Northeast or only in Connecticut or Massachusetts may have an advantage over a national company in that particular market and so forth. The argument against them is that they offer reliable services at low prices. And this is because there are always some kind of collateral benefits that are supposed to be around from this. And we've been trying to find those collateral benefits for years. But I think in the end, what happens is that the argument is that straight efficiency arguments on antitrust are correct. And if there are other issues, for example, like dealing with privacy questions, which I think are very important, they have to be addressed by other tools and by other means. I mean, I could recall years ago, Ralph Nader and I had a debate on a particular case, and he basically wanted to use the antitrust laws to improve the weather. My view was that you stick to market structure.
And now we're trying to use antitrust laws for everything: content moderation, privacy, quality, the environment, and that's just going back to the 1960s, and now Republicans are endorsing it. So with that, any concluding thoughts from either of you for 30 seconds each? John?
I would start by saying that I do think that Judge Callahan wrote a very strong opinion. I think that the chances of applying for cert, and let alone granting cert, are zero, essentially. I do think there is a risk that Judge Thomas, the Chief Judge of the Ninth, could ask for en banc review, but he generally tends to do that on social issues like gun control or abortion. Antitrust is not sufficiently sexy. And this is an interesting case where you have two administrative agencies at loggerheads over the same issue in the same case. That's a little unusual.
It's also important on this to understand, as I've seen in other markets, the enormous influence that something like the DOD and the State Department have on these issues. It is an extremely important principle to understand that private enforcement of the antitrust laws interfere with foreign relationships. And I could think it was Anthony Scalia who actually argued one of these cases before he went on the court, where there was a per se rule that if you're trying to deal with international stuff and you don't get yourself the support of the State Department or the military department, we just don't want to take this thing further because now it's more of a separation of powers issue and less an issue of whether you think that the markets are efficient or not. So antitrust intersects these way, and everything that John said about the internal dynamics is true. And when you throw in this foreign policy overlay and remember the breadth of this particular decree, I don't think the Ninth Circuit's going to intervene either.
I agree. And with that, I think we're adjourned. I'd like to thank both of the panelists for coming out today. That was really terrific. And for everyone in the audience, this will be available on YouTube later. It will also be on the Committee for Justice website, committeeforjustice.org. And I'd also encourage you to, like I said earlier, check out our new coalition of organizations who are kind of taking this sort of stance on antitrust law, and that's Alliance on Antitrust, and that's allianceonantitrust.org. With that, we are adjourned. Thank you all.
Thank you.
Bye-bye all. And great to see you, John and Ashley.
You too, Richard.
Bye.
Take
Good to
care.
see you again.
Good Shabbos.
Oh, thank you.